The last case is Gonzalez-Castillo v. Garland, Ninth Circuit, just last week. This is about Interpol red notices, which have a special place in my heart based on some of the work that the Kurzban firm sometimes does. And it's about this case, Matter of Werb, which I love saying, which is a BIA case about red notices. What were you going to say?
I actually talked about this briefly in my separate podcast, because like this Interpol red notice thing is the thing that gets on my last nerve that it exists the way it does. I didn't get too much into it because I haven't read up on it for like a year. It's the last case I had on it. So I'm glad you're going to talk more detail for those listeners. So I just said, know about it, but I'm not going to tell it to you. But you have a chance to talk about it.
Here you go. Listen to last week's episode of the pod. But yeah, no, it's great. It's great for two reasons. First, red notices, but just burdens in general. It's in the context, as it so often is, in the bar to asylum and withholding of removal if the non-citizen has committed a serious non-political crime. But the provision that bars asylum and withholding is that if there are serious reasons for believing that the non-citizen has committed a serious non-political crime. I mean, it's the epitome of mushy. What the hell does that mean? You don't have to have a conviction. It's just serious reasons for believing. That's what the IJ has. But like, non-citizens have the ultimate burden to establish eligibility for relief in immigration court. Everybody agrees on that. But like, it's not like you have to come in and disprove a negative. I mean, there are a million bars to everything. You don't have to come in and prove that you didn't commit genocide, right? If there's no indication that if you weren't in Rwanda or Yugoslavia during the 1990s, I mean, there's other genocidal places, I know. But anyway, so Matter of Werb says, serious reason, whatever that means, I don't know, but actually it says more. Werb is better than that, but whatever it means, I don't know. But all DHS has to show is that the evidence indicates that it applies, and then burden shifts to the non-citizen to disprove that. Evidence indicates. I mean that means nothing. That means anything. That means somebody said it on the street corner because hearsay is admissible in immigration court. I mean, the evidence indicates. And I have been fighting this evidence indicates standard in a variety of courts for a bit now, because that's not what other BIA decisions say. And it doesn't make sense under the statute. It doesn't make sense as an understanding of law. I mean, that's crazy. And Gonzalez-Castillo says two things. First of all, it says three things. It says the serious reasons to believe standard under the INA equates to probable cause. That's what that means. So the bar applies if there's probable cause to believe that the non-citizen has committed a serious non-political crime. What does a serious non-political crime mean? That's a whole other thing. This case isn't about it. But you have to have probable cause. All right, I can deal with that. That's Ninth Circuit precedent. That's also precedent in other circuits. Then the Ninth Circuit says Interpol red notices don't equate to probable cause. That's DOJ itself. There's DOJ policy that says Interpol red notices are not probable cause. I mean, that's the most uncontroversial thing in the world. It shouldn't even be an issue. DOJ says it as official policy, but of course, that's not what happens in immigration court. The Ninth Circuit is saying that quite clearly. Interpol red notice by itself cannot satisfy the serious reason to believe serious non-political crime, because that equates to probable cause, and a red notice is not probable cause. Makes sense, right? Eighth Circuit said a similar thing. I believe, no, Eighth Circuit said what I'm about to say as well. Other circuits have said that too, but DOJ says it. Immigration judges and BIA are part of DOJ. But DOJ says that too. But then the most important thing, right? Because of course the BIA knows this. That's probably why they issue Matter of Werb. Ninth Circuit says that whole burden thing, that's not a thing. The evidence indicates you don't shift it. There's no shifting to the non-citizen, because we don't care what the regs say. We don't care what Matter of Werb says. The statute doesn't talk about a burden shift. Doesn't talk about any of this. It just talks about serious reasons for believing. So an immigration judge can never sustain a serious reason for believing serious non-political crime allegation based simply on a red notice. No, burdens be damned, because the record will never establish it. because there will never be probable cause based on a red notice alone. That's what Gonzalez-Castillo says. It's a big deal, I think, for all this. And, it's more nuanced. This isn't legal advice. A lot is said in Castillo. So give it a read. Also, big props to the University of California, Berkeley School of law students as well for this big win, for this great case law on the 9th. It's a big deal. Love cases like this.
Yeah. This red notice thing is such an abused kind of thing. It's that I'm so glad that it's getting more attention. Then just at a practice angle, there are a couple of immigration attorneys that have a whole practice just dealing with red notices. They've gotten known for it. So, if you get the hang of it, how to contact Interpol, try to fix it, take it off, or deal with it, all that kind of stuff. That's a whole niche that you can get into if you want to expand your practice.
It is. We often use, God, it's very hot. I'm sorry, in Southern California, my brain's working at half speed. We used. Oh my God, we use a big firm in Miami often when there are red notice issues, and I want to give them their props. We use Greenberg Traurig in Miami. They've got a whole practice area for red notices. That's who we often use. There are other individuals as well, but Daniel Palacio, I believe is his name, at Greenberg. He knows how to deal with Interpol. And so much of this is discretionary, burdens, all of this is great. But if you're going into court with a red notice, you're already at a disadvantage. So it's always, to take it a step further, these are usually asylum cases. If Interpol, so I argue so often, if Interpol is refusing to recognize a country's request, to return this non-citizen for prosecution, because Interpol is saying we don't trust the request from this country. And that's what happens often when you get Interpol to withdraw the red notice. If Interpol says that, to me, that's strong indication that this individual is going to be persecuted in their home country. Because look, even Interpol don't trust this country.
Yeah,
I think it's a legit argument. So shoot me an email, hit up Greenberg in Miami and Daniel, and they often do great work from these countries that abuse the Interpol process.